Dear viewers, welcome to yet another episode on course of property law. I am Dr. Shivani Verma from Law Center 1, Faculty of Law, University of Delhi, and today we are going to discuss a topic that is doctrine of election. So let's start with introduction. Doctrine of election in law originates from multiplicity of choices in context of rights. It is then when doctrine applies and the elector elects any of the rights which he is at a liberty to choose, but not all of them. The right which he chooses then becomes exclusive and exerts an estoppel on him. It is said that election is the obligation imposed upon a party by courts of equity to choose between two inconsistent or alternative rights or claims in cases where there is clear intention of the person from whom he derives one that he should not enjoy the both. That he who accepts a benefit under a deed or will must adopt the whole contents of the instrument. Along with the property law, that is, the Transfer of Property Act of 1882, the doctrine of election has a universal applicability and is incorporated in various personal laws also, like for Hindus, Muslims, and Christians. The concept deals with a choice which a person makes in form, with his free will and unconditional will. It is a doctrine based on the concept of equity, which asserts that the person who approves or accepts a transfer, he thereby substantiates the adoption of it as a whole, or its rejection also creates the renunciation of the transaction in entirety. In the case of T. Muthukumar Swamy versus J. Selva Sundaraja, the doctrine has been formulated on the basis of its applicability as follows. 1. The doctrine will not be applied in the cases where the scope and ambit of the two remedies are completely different. Second, there must exist two or more remedies which are inconsistent, so that after election, while pursuing the remedy, there would be no conflict of interest. While choosing the doctrine in the matter of Cordington versus Cordington, it was held that the doctrine is based on a fundamental principle that the right to exercise the choice when lies with a person and he exercises that choice with free will, then it binds him with the choice that he makes voluntarily. The concept is built upon doctrine of equity, which propounds that acceptance or rejection must be applied and adopted in a whole. A person cannot renounce and accept a transaction at one point of time. The Transfer of Property Act of 1882 under section 35 talks about the doctrine of election and its applicability in detail. It is said to be based on the maxim elegans contraria non est audiendum, which means that a contrary statement isn't to be heard by the law. While in England, the doctrine of election is majorly based on the concept of equitable compensation, in India, the law majorly focuses upon the concept of forfeiture. Learned Justice Banks, in the matter of Slattery versus Pooley, explained the underlying principle of election as having elected to treat the delivery to him as an authorized delivery, they cannot treat the same act as a misdelivery. To do so would be to approbate and reprobate the same act. Now, election in context of property means that any movable or immovable property has been transferred by a transferor who did not have the right to transfer this property, and through the same transaction he has also conferred certain benefits to the owner of the same property. Now, this person, the transferor, shall be assigning two sets of the rights to the owner, who in turn may elect any one of such assigned rights. If the two rights are such that they cannot be enjoyed together simultaneously. Hence, the doctrine of election that the owner has to elect in the above given situation and will then elect either to accept and hence confirm the transfer or completely reject it, but at no point of time he can take the benefit of the both. Once such person elects and makes his choice, then depending upon his election, he must adopt the whole of it or renounce it completely, including each and everything which is inconsistent with it. The Transfer of Property Act of 1882 clearly lays down the situation and the elements also that constitute the election in the matters of property under section 35. Now, let us understand rules associated with the doctrine of election. So, when the election is required? Whenever a transferor admits to transfer such a property on which he did not have any right to transfer, and such transferor also through the same transaction confers a benefit or benefits in favor of the owner of such property. That is when the owner gets to elect and the nuances of the doctrine are applied. In such situation, it is irrelevant whether the transferor who entered into such transaction believes or does not believe that the property which he professes to transfer is it to be his own or not. This situation creates two choices for the owner, out of which he is required to elect one. The option to elect are from either confirm such benefit conferred or dissent or discard them completely. Only the person who is taking a benefit directly can elect, and anyone who is not taking any benefit directly under the said transaction and is only deriving some benefits indirectly from the transaction cannot elect. If the person is involved in two capacities, if he takes benefit in one capacity, he has a choice to accept it in one capacity and dissent therefrom in another capacity. In the matter of Dhanpati Devi versus Devi Prasad, it was propounded by the court that election as a concept activates only when transfer of the property is done by a person who did not have the right to make this transfer, and through a part of the said transaction, he also must have conferred a benefit or benefits onto the owner of the said property, and only then the such owner of the property gets to elect. He can either confirm such transfer or he will have a choice to dissent from it. Hence, the basic rule is that a person simultaneously cannot approbate and also reprobate. This idea is basically derived from the Scottish law, where it is expressed that the basic principle underlying the doctrine of election is that a party cannot accept or reject the same instrument. However, the doctrine is not restricted to the instruments only. A person cannot basically sail on two boats and take a stand wherein at one time he accepts that a transaction is valid and then obtains certain advantages therefrom, which he would rightfully only be entitled if he takes a choice to call it valid, and then also he jumps onto the other boat and calls the same transaction void, thereby securing some other and different advantages. This is called approbation and reprobation of the transaction simultaneously to gain maximum benefit, and this is evidently against the concept of equity as well as the concept of estoppel. Under section 35 of the Act, the doctrine can be understood with the help of an illustration. Rajvilla, a house, is the property of X and it is worth 80 lakh of rupees. Y transfers this Rajvilla to Z through a gift deed, and in the same instrument of gift he also gives X rupees 90 lakhs. Now, X will have two options. He can either choose to retain the house, and if he chooses to do so, he will have to forfeit the amount of 90 lakh rupees. If he chooses to accept these 90 lakh rupees, then he will have to forfeit his rights on Rajvilla. Election, as it attempts to create fairness amongst the parties, is a doctrine that is based on principles of natural justice, that is, equity and justice. It clearly asserts that a person cannot accept the beneficial part and disapprove the part that is not in his interest created under one same instrument. Approbation and reprobation can't run together for a same instrument, because picking and choosing the advantages from one instrument and discarding the disadvantageous part of the same instrument is not what is allowed. It is fair that if a person takes some benefit under a deed or instrument, then he must also bear its burden. The entitlement to elect is a qualified right guaranteed to the transferee only when he is one who takes or extracts the benefit out of the transaction in question directly. In case of Valyamai versus Nagappa, the court said that when the transferee not directly but indirectly derives the benefit from the said transaction, that no question of election would be arising, as in that case the person in strict sense cannot be said to take any advantage or benefit under the deed. Now, let us understand the effect of election. If the benefits are accepted, he will be bound by estoppel to all the consequences and in entirety. If the benefits are dissented, then he will also inevitably relinquish all such benefits as were conferred upon him in the transaction, and such benefits will then go back and return to the transferor as if they had never been disposed of. However, the value or the amount of the property is to be attempted to be transferred to him. In the case where such transfers are without consideration, that is gratuitous, and the said transferor either died or due to any other reason became incapable to make a new transfer, and in such cases, in order to compensate the disappointed transferee, the transfer was made as a consideration. If the owner elects to disapprove the transfer, then he is required to surrender all the benefits conferred upon him through the transaction back to either the transferor or to his representatives in such a way as if they were never bestowed upon him. Upon such disapproval by the owner, the transferor must compensate the donee or the transferee. He who elects is under an obligation to make the instrument under which he asserts and takes the benefit fully effective. If instrument creates implications and deals with something which was beyond the power of transferor to dispose of, but there is a concurrence and effect can only be given in concurrence of the person who receives the benefit under the same instrument, then the doctrine will ensure that he who takes the benefit also bears the obligation to carry the instrument in absolute and complete force and effect. The doctrine of election is a derivation of rule of estoppel. It establishes that if a person approves a transaction by election, he is barred from asserting a contrary or alternative right later, which he could have had if he disapproved the transaction. As per the Honorable Court in the matter of Messrs. Forbes v. Private Limited versus Mr. Turbovent Industries Private Limited, the doctrine restricts the right of the pleader pleading for the remedy if there are two remedies available for the same claim and the two remedies are inconsistent with each other, then the aggrieved party has to opt and choose one. He can in no case opt and enjoy the both. In the matter of Muhammad Qadar Ali Fakir versus Fakir Lakshman Hakim, the Honorable Court explained the concept of election as: the basis of the doctrine is making a choice and not taking a stand for or against a benefit conferred in the same transaction. The general rule is either to approbate or reprobate, but not to plead the both. Presumption in reference to the intention in such case will be that the maker of the instrument intended to give effect to each part of it. A person taking the benefit under an instrument is under an obligation to give full effect to the whole instrument to the full and complete effect and force. Now, let us understand the exceptions of this rule of election. First is relinquishments of the particular benefits. In this case, where through the transfer that the transferor professes to transfer a benefit particular in nature is conferred upon the owner of the said property expressly, and such benefit is clearly expressed to be in the lieu of the said property transferred, then in such case, where such owner asserts his claim to get back the property, he cannot enjoy the benefit and he must in entirety relinquish that particular benefit. However, at the same point of time, as far other benefits are conferred upon him by the same transfer are concerned, he is not bound to relinquish them all and he may keep on enjoying them. Second is acceptance by election. If the party upon whom such benefits are conferred is aware about his duty about election and has the knowledge about all the circumstances which would reasonably influence the decision or the judgment of any reasonable person while making an election, or in case where such party waives the inquiry about any such circumstances, then acceptance of any such benefits by the party upon whom these benefits were conferred establishes and constitutes that election was made by him in such a way as to confirm the said transfer. In case of Paru Kuttiyamma versus C.N. Lakshmi Amma and others, while discussing the concept of election in concept of will, it was held that to entice the applicability of the doctrine of election, there are prerequisites that are needed to be complied with. First, the one who gets the benefit is the owner legatee, and then this owner legatee is put on to the spot wherein there is a requirement of the election. An election as to make a choice whether he would approbate and accept the said property. If yes, then he will have to allow all the bequeathed property to be completely devolved in such a manner as prescribed and provided by the said testator. The core idea is that he cannot accept a part and reject another part of the instrument in order to receive the maximum benefits. The affirmation or disaffirmation both are to be in reference to the entire instrument and transaction. The underlying principle of concept of election is that parties are to choose instead of riding on two horses. A party cannot accept and reject the same instrument just because it is beneficial that ways. The doctrine propounds that a person cannot say at one time that a transaction is valid and thereby obtain advantage to which he could only be entitled on the footing that it is valid, and then turn around and say that it is void for the purpose of securing some other advantages. The doctrine is based on equitable concept of estoppel in pairs. It is a rule of fairness, and as held by the court in the matter of Ramesh C. Sankala versus Vikram Cement, it was said that a person, when it is his duty to speak, may be precluded by his actions or conducts or silence from asserting any other right that he would otherwise have had. Presumptions. If the evidence to the contrary is absent, then knowledge or waiver are to be presumed. If for 2 years the person enjoyed the benefits which were conferred upon him and did nothing to express his dissent thereto. If any act done by the person upon whom any benefit was conferred makes it impossible to put the persons who are entrusted in such property in the same place or condition, as if such act had never been done, then such act will be inferred as knowledge or waiver. Now let's understand limitation period. 1 year is the period prescribed for election. If neither the intention to confirm nor the intention to dissent is signified to the transferor within the time period of 1 year after such transfer, then within the reasonable time period after such requisition was received, the requisition from the transferor has to be acted upon. After such reasonable time, it would be deemed that the election has happened to the effect of confirmation of the transfer. Let's understand this with help of an illustration. An estate which C has the entitlement upon was transferred from A to B. Through the same transaction, B gave a coal mine to C. If C takes the possession of the coal mine and starts extracting coal therefrom, he thereby confirms the transaction and the estate will be confirmed to be conferred upon B. Hence, there are two ways by which election can be established. First is direct and the second one is indirect. In the direct election, a person elects and chooses on the basis of his choice from the available alternatives, while in the case of indirect election, the election is deemed to have taken place on the basis of behaviors or gestures of the person who was to elect. To constitute direct election, one must have the knowledge and awareness about his responsibility to elect. It is important to establish the presence of the evidences to prove that the individual who was to elect was aware of the conditions and the circumstances that might affect his decision like a reasonable person. When election is made, benefits can be availed from the transaction and the acceptance of such benefit amounts to approval or confirmation, that is, the election to assent the same, provided the person was aware of his duty to elect or he waived the inquiry due to lack of reasonable judgment. Such waiver is presumed in the absence of any evidence to the contrary if the person has been enjoying the benefits of the transaction for at least the time period of 2 years. Within 2 years after receiving the benefits, if the receiver does not show any expressed or implied sign of objection or rejection, then it is presumed that he has been aware of the transaction and all the conditions incorporated therein, and freely he has chosen to affirm it in totality. In case of disability in the person who has to elect, the date for election can be postponed in two possible ways. One, till the time the disability ceases to exist, and two, till the election is not made by the competent authority. The courts have evolved the doctrine of election as a doctrine of equity. It creates a fair outcome wherein a man needs to elect and cannot be allowed to accept and reject simultaneously. If a transaction poses two completely inconsistent rights and a man chooses a right, he intentionally relinquishes the other rights arising out of the same transaction. Once election is done, the rights not elected are considered to be intentionally given upon. So that is all about doctrine of election. Thank you so much.